it depends. So let me start with Chapter 7. Now in Chapter 7, there's going to be a Chapter 7 trustee. If it's a business, Chapter 7, the trustee is going to take all of the debtor's assets. The debtor has no say in what's going on. The trustee will take all those assets and liquidate them and have money to pay creditors. Creditors file proofs of claim, and it's the trustee's right to challenge proofs of claim. The debtor doesn't have authority to do that. Similarly, in a personal Chapter 7, well, the trustee is taking all of the non-exempt assets and liquidating them to have a pot of money to distribute to creditors. And if a creditor files, let's say, a grossly inflated proof of claim or a fraudulent proof of claim, it's really up to the trustee to challenge the legitimacy of that claim with some sort of contested matter. I suppose a debtor might argue that in the limited circumstance where that particular creditor is not going to be paid in full through the liquidation and the debt is determined to be non-dischargeable, that the debtor could have standing to challenge the claim because there will be harm after the bankruptcy if the debtor still owes that debt. But if it's a dischargeable debt and the creditor has filed the proof of claim to get paid, then the debtor really does not have standing in a Chapter 7 bankruptcy to file a claim objection. Things are a little different in Chapters 11 and 13, where the debtor is going to be making these payments to the creditors. And if there is an illegitimate proof of claim, the debtor may end up having to pay more than the debtor really owes to that creditor. So there, a debtor can challenge a proof of claim, and I've certainly done that plenty of times. The most common challenges are duplicative proofs of claim. Had a case a while back where a creditor filed 3 separate proofs of claim that were the same, and they were for fairly large amounts of money. And if I didn't challenge at least 2 of those, then the debtor would have to pay that debt 3 times. So obviously we're going to challenge the duplicative proofs of claim. And in my view, filing duplicative proofs of claim is filing frivolous pleadings. So we'd also like to get sanctions in a situation like that. There can be proofs of claim that are filed that have claims that are well past the statute of limitations. And I guess about a month ago, I filed a claim objection, or maybe it was 2 months ago because the judge already ruled on it. 2 months ago, I had a claim filed in one of my cases where the creditor was seeking to collect on a debt from 2004. It's now 2021, and this was on a credit card debt that the entity that was filing the claim had purchased or allegedly purchased in 2004. So we challenged that, and the judge sustained the challenge. So that would certainly be another one in which it would be legitimate for the debtor to challenge. Yet another is if the claim is grossly inflated. So it helps to know, for example, that the judgment rate in California is 10% per annum, but it's simple interest, not compounded interest. So let's say a creditor got a judgment against a debtor, and so the interest is accruing over time, but the creditor has computed the interest using compounding rather than simple interest. They're very different concepts. Well, at that point that the creditor files that proof of claim, the claim may be asking for a great deal more than the creditor is entitled to receive. So in that situation, we would certainly file a claim objection and initiate that contested matter. Or let's say the creditor says, you owe me $300,000, but the debtor has receipts and documentation to show that $200,000 has already been paid. Well, then we do a claim objection on that to say, sorry, pal, you're only entitled to $100,000. So yes, debtors can challenge a creditor's right to payment on a proof of claim, whether challenge on the dollar amount or challenge on the entire legitimacy of the claim.